Guys, today we have IRM1501, which is the law of research. Most of you are doing first year. You have to register this module. It's a compulsory module for LLB. So here we'll be discussing assignment 1 and assignment 2. And today we will only strictly discuss question 1 from assignment number 1. It's very much important for you to submit assignment 1 on time, because assignment number 1 grants you permission to the examination. So it's very much important. So without wasting any time, let's go to the business of the day. Question number 1. With relevant decided cases, discuss transformative constitutionalism and identify 3 basic principles of transformative constitutionalism. One of the things that you must know is that the law of research IRM, if you can check it in the study guide, is so slim in a way that it doesn't have more information. It's up to you to go and seek more information. That's how the lawyer, as a lawyer, you must do, to go and seek the information. Now, this question, most of you may have read and not understood the question. So I want you to understand what the question is asking. The question said, with relevant to decided cases, discuss transformative constitutionalism. It means that you are going to discuss transformative constitutionalism based on decided cases. And you are going to identify the 3 basic principles of transformative constitutionalism based on those cases. I hope now the question is clear. So without wasting any time, we'll go straight to the first case, which is the case that is common to everyone. Is the case of Makwanyane versus the state versus Makwanyane and the Mukunu. Okay, this case was heard on the 15th February to 17th February 1995, delivered on the 6th June 1995. I'd like to give you some background before. That's why I've read that it was heard on 15th February and delivered on the 6th June. I want to give you some background so that you understand. You must understand that in 1990, Nelson Mandela was released from prison. As a result of that, the constitution that was ruling that time, it was the parliament was supreme. Then they needed to change the constitution of that time. And then they adopted the interim constitution of 1993. Let me repeat, they adopted the interim constitution of 1993. And this case was heard. Remember, the constitution of South Africa, which we are currently in now, was adopted in 1996. So this case was heard in 1995, which means that the interim constitution of 1993 was still applying. That's the things that I'd like you to know. In this case, there was 2 accused, obviously, Makwanyane and Mukunu, who were convicted for 4 counts of murder, 1 count of attempted murder, and 1 count of robbery. And they were sentenced to death on each of the counts. Remember, in the previous constitution, before they adopted the interim constitution, South Africa used to sentence people to death. This was done by section 277, subsection 1, paragraph A of the CPA, which prescribed death penalty as a competent sentence for murder. But now this section is repealed and amended. I'd like to state that another issue is that now it's the interim constitution of 1993. So they have to check whether this section is consistent with the interim constitution. And in the interim constitution, there was 2 sections, section 9 and section 11, subsection 2, which were also the milestone But I'm not going to discuss the full case, what happened in this case, and all those cases. I'm just giving you some background of the case. So I have summarized the case, and let me put it in the summary. In the summary, that these two were convicted of those that I've already mentioned, and they both sentenced to death. Then they appealed to Supreme Court against their conviction, and then death penalty was commuted sentence for murder according to Section 277, which I've already told you. And then I've already told you that South Africa adopted interim constitution of 1993, and then they have to check whether the death sentence is consistent with the Section 9 and 11 of the interim constitution. And the legal question here was whether Section 277 of the criminal procedure is consistent or inconsistent with the interim constitution. The other questions was the implication of Section 241, subsection 8 of the interim constitution. And then a ratio decident is that South Africa needed to deal with the past. Remember, South Africa has to deal with the past, which in the past there were many black people who would just be sentenced to death, which was not a suitable or competent sentence. You know, remember that there was a full of discrimination that time. The Constitution was based on Section 11, subsection 2 of the interim constitution, which prohibits cruel, degrading punishment. And another thing is that the Constitution has to interpret the provision of the Constitution based on the Bill of Rights, which were there on the interim constitution. Then they decided to adopt Ubuntu, which is the first principle that we are going to talk about. So the first principle of the transformative constitution is the Ubuntu, which was adopted in this case of Makwanyane. Okay, I'm just giving you some summary of the case. It's up to you to go and reread this question. But I love this part where they say the court also considered that the death sentence applied mostly to the people due to their social economic factors. Some were sentenced to death because of lack of financial resources, and some because of they belonged to certain race. Majority of black people were poor and were disadvantaged in a way that they can't defend themselves in court of law. And this created inequality in terms of law. Okay? This is how they decide the court. The court favored the approach which was taken from the case of Fuam versus Georgia, in an application of Section 2771, which held that the death sentence was cruel, inhuman, and degrading punishment. And they also go ahead further by saying that the capital punishment was constitute a serious infringement of human dignity. It imposed limitation on the fundamental right to dignity and life. And then there was many things that we emphasized. The Candler case emphasized the importance of a right to life. There were many here. It's just my summary, which you have to do your own summary in order to understand the transformative constitutionalism. In the West Virginia State Board of Education versus Barnett, it was held that the purpose of the Bill of Rights should withdraw certain subjects from public controversy and establish the rights which become legal principles to be applied in court. They also focused on the international cases such as United States and India. Then they found that the death sentence was regarded as cruel, inhuman, and degrading punishment. But remember, today we are not summarizing the case of Makwanyane. I was just giving you some overview of the case of Makwanyane. The thing that I want to talk about is the notion of Ubuntu. which is the principle that was adopted in the case of Makwanyane, which is the number one in the transformative of constitution. So now you know that another principle is Ubuntu. Ubuntu was in the post-amble of the interim constitution. Ubuntu has become a distinctive African value which embodies deep notions of togetherness, humanness, and solidarity. It was a Madala J expressed that the death penalty ran counter to the concept of Ubuntu. The Ubuntu must be applied even in the heinous offense for possibility of rehabilitation. Mahoro J recognizes the importance of indigenous South African values. One of those values was Ubuntu. He described Ubuntu as a humanness, personhood, and morality. Ubuntu incorporated the key value of group solidarity, compassion, respect, human dignity, and collective unity. It has a notion which embraces respect and value for life. Ubuntu spirit emphasizes respect for human dignity, making a shift from confrontation to conciliation. The Constitution mandated that when court interpreting the Bill of Rights, must consider the African value system such as Ubuntu. Ubuntu is one of the values which is important element in the future legal development. Shackleton held that the Constitution will be consistent with the value of Ubuntu if the society doesn't wish to kill criminals, but rather wish to prevent crime. Muhammad J. held that Ubuntu expresses the source of instructive capacity for an enjoyment of love towards our fellow men and women. This joy and fulfillment include the reorganization of their innate humanity. Mahoro J. expressed that Ubuntu has been seen as a morality of cooperation, compassion, communalism, and concern for the interest of collective respect for the dignity of personhood. Langa J. highlighted Ubuntu communal spirit. He held that it emphasized on the interdependence of the member of the community. It recognizes that each person is made of humanity and unconditional respect, dignity, value, and acceptance from one's community. Langa of KwaZulu-Natal versus Pila held that Ubuntu is a notion which is central to understanding the individual in African thought. So this was Ubuntu. Remember, and this is very crucial, you will be asking to discuss the notion of Ubuntu throughout your LLB. Even when you are doing the fourth module, fourth year of LLB, you will be still answering the questions based on Ubuntu. So it's very much important for you to have a broader understanding of Ubuntu. And I think the way, I put it is very understandable, and it enlarge your understanding about Ubuntu. So you can able to make the summaries about the notion of Ubuntu now. So it's very much important for now to understand that when we talk about the transformative constitution, it means that we have to transform the way things were done in the past and try to bring equality and social justice. Let me repeat. In the past, there was a discrimination. So now they have to build a society which is based on equality. And that society must achieve social justice. So now we have understood. Let's go straight to the then I have put it in this way that the transformative of constitution is a transformation of the state and society into a democratic country to achieve substantive equality. Muyongani held that the constitution is inclusive of justifiable social economic rights and its transformative agenda. South Africa has a separation of powers, which vested power into legislature, executive, and judicial. The judicial is supreme of them all. Constitutional Court or CC is the apex court which extraordinarily power. In the Executive Council of the Western Cape Legislature, this as President of the Republic, the CC extraordinary power was proven when it invalidated the law of the democratic parliament. Substantive equality is achievable through creation of transparent rules which bring an end to social inequality and economic inequality. The transformative should end the discrimination based on race, color, and sexual orientation. Formal equality is achievable by treating people equal as envisaged in Section 9 of the Constitution. And this is very much important, but let me pass this one because this one, it doesn't deal with the transformative. Mostly it deals with a customary law. So it's of the things that I will test, and then I will check this one. Yeah, now another fundamental. Another principle is the freedom of speech stipulated in Section 16 of the Constitution of South Africa. Although the freedom of speech is not absolute, the limitations are subject to the limitational clauses. The freedom of speech must not incite violence, must not spread propaganda of war, and a hate speech towards religion, race, or group. The nature of hate speech is prohibited by Section 10 of the Promotion of Equality and Prevention of Unfair Discrimination Act. Vicky Mombeck was sentenced to 3 years for referring black police as kafir for more than 48 times. You know about that Vicky Mombeck video where she was marked in sentence, then the black police tried to assist, then she called black police as a kafir. She referred black police as a kafir for more than 48 times. Vicky Mombeck is the first one to be sentenced to 3 years in prison for racism. This is the milestone. This is the achievement of the court by. This is the achievement by the court for transformative constitutionalism. When Mombeck Vicky went to prison for 3 years for referring a black police as a kafir for more than 48 times. Then we have another case of Penny Sparrow. If you can remember Penny Sparrow is that woman from Cape Town who likened black beachgoers to monkeys. There was a post that she posted that the black man, from today, she will refer black beachgoers as a monkeys. When she said that white people are not enjoying the freedom during the vacation or during the holiday, because the black people will jam-pack the beaches. And as a result of that, she likening black beachgoers to monkeys. She was in prison for 3 years. However, she later paid the fine. So she never seen the prison. It was suspended, and she paid the fine of more than 100,000. That is another case for transformative constitutionalism, which shows that there is a transformative constitutionalism in South Africa. And for the broader knowledge, you have to read the transformative constitutionalism and customary law, but you'll be reading much about transformative constitutionalism and the customary law, because I think that is one area that we must focus. Customary laws are not applied much in court, and we have to be specific and we have to deal with it. So this is the journal article by Anika Kleisens Gojov Badelnda, which I think that you must go and read it. You will learn much about the transformative constitutionalism. You will learn more about the cases. Remember, as a UNISA student, reading more journals will make you the best lawyers of all time if you want to be a lawyer. So reading journals is one of the ways to become a competent lawyer. So read more journals, and those journals articles will help you will build you area. Okay, that was today. We'll come and deal with another questions on the part 2. This was just a part 1. Thanks for watching.